A motion in limine is a legal request made before trial to exclude or limit certain evidence or arguments during a trial. The phrase in limine means at the threshold, and it's a way for attorneys to address potential evidentiary issues before they arise at trial. April 9th, 2025. This is motion number 3 for the state's motion and regarding who can attend trial, putting Bryans' family on notice that they may be called to testify, which actually bars them from attending trial, which is the said issue at hand.
All right, let's talk about who is going to be in the courtroom amongst the victims and the defendant's family in general in terms of a reserved seat. I'm not as concerned about the reserved seat part. We can address that at the pretrial conference down the road. I'm more concerned about the ability to be in the courtroom notwithstanding an exclusion order of the court of witnesses. So let's address that issue.
Your Honor, the state filed this motion in order to seek clarification of the court's definition of immediate family member pursuant to Idaho Code 1953-06-1B. As you know, that specific code section doesn't give us a definition of immediate family member. The state has given a proposed exhibit, State's Exhibit S1, which we think are justified as being immediate family. It's my understanding that defense has stipulated to that list, and we would just ask the court to issue an order to that effect. This takes care of the issue that the state raised. I don't know if you have any further questions.
Well, there is the issue of the defendant's family, but that's, I think, the defendant's motion, so I'll let them address that first.
April 9th, motion number 3, defense's response of who can attend the trial.
The state submits that by simply placing our client's family on its witness list, that is enough to warrant exclusion, and further, that they may call family members. I want to note that they have not subpoenaed them, the state's attorneys have not interviewed them, and they know that Mr. Kohberger's family does not have any interest in helping them. They also know from watching all of Mr. Kohberger's video visits how much his family loves him and supports him, and that he is absolutely dependent on them, having been in isolation for almost 2.5 years, and by the time we get to trial, it will be almost 3 years. His parents attend every court hearing, and the only reason that they are not here in person is that they do not have the money to fly back and forth from the East Coast. If they had the financial resources, they would be here in person every single court date. Sequestration of witnesses under IRE 615 is discretionary. The language in the statute is that they may be excluded by the court. This means that there's court discretion in that decision, and there's a reason for that. The reason is that the court must balance Mr. Kohberger's constitutional right to a public trial with other needs of the case. In the United States Supreme Court in Ray Oliver in 1948, the court stated, "Without exception, all courts have held that an accused is at very least entitled to have his friends, relatives, and counsel present, no matter what offense he may be charged." The Tennessee Supreme Court recognized the same precedent in State v. Sams in 1990. In that case, the prosecutor subpoenaed all of the defendant's family to keep them out of the courtroom. In reversing the case over this issue, the court held, the assistant district attorney's blatant abuse of the trial court subpoena power for the exclusive purpose of removing the relatives from the courtroom constituted egregious prosecutorial misconduct. The state action violated the constitutional right to public trial, as well as the constitutional right of the relatives to attend the trial. In a more recent case in Iowa in 2022, State versus Bremer, a conviction was overturned when the accused family was excluded from trial due to COVID-19. The court pointed out even the defendant's mother was excluded. The purpose of the witness sequestration is to prevent a witness from tailoring his or her testimony. In this case, all of Mr. Kohberger's immediate family were interrogated in the middle of the night when he was arrested. All of their interviews are videotaped. There's no tailoring of testimony to be done. Add to that the evidence that the defense has disclosed to the state in discovery and expert opinions, which the court has had the ability to review. Those provide an even more narrowing, who it would be even rational probably for the state to actually call. At best, there's one potential family member that they may see a reason to call. The state knows that Bryans' family has no desire to be used as witnesses against him. From the minute this trial begins, the jury is going to study Mr. Kohberger, and they are going to figure out who is in this courtroom sitting behind him to support him. Weeks into the trial, the jury is going to know who's in the gallery. That's why there is a constitutional right to a public trial, so that what happens here is not done in a star chamber, and for our client, the jury will know that he has people there to support him. Mr. Kohberger needs his family to support him. As the court knows, we have several motions that we will be addressing regarding his autism spectrum disorder. He needs to have his family here to support him, and they need to be in the courtroom supporting him. These needs are constitutionally protected rights. We ask that you enter an order making it clear that the state does not get to put his family members merely on a witness list and keep them out of the courtroom. If they want somebody in court, there needs to be an out-of-state subpoena issued. They need to provide witness travel funds to be here and make their intentions very clear. And then this court, we ask, exercise its discretion and allow whoever of those family members the state may actually subpoena to be in the courtroom, because there's no need to worry about how they may tailor their evidence, because it's their testimony, because it's all video recorded. And the court could also order the state to make it those witnesses, if they do intend to call them, immediately call as witnesses early on in the case, so that if there is for any reason going to be exclusion, that exclusion would be there for a very short period of time. But we do ask the court to consider how important in opening statements, when that jury walks in and they're making that immediate first impression assessment, how important it will be for Mr. Kohberger to have his family sitting behind him. We've also asked in our motion that the court address decorum, since the court's going to be issuing an order. As we pointed out, there's been some history in this case with clothing being brought into the courthouse that's pro-death penalty and pro-firing squad. There's no place for that in this courthouse at all during these proceedings. There's no place for that in this courtroom, and we'd ask that the court issue an order that spelling out very clearly that that will not be allowed. Thank you.
April 9th, motion number 3, states rebuttal of who can attend the trial.
Your Honor, the state trusts that this court will enter your own standards of decorum for the courtroom, and the state will advise our witnesses and immediate family in accordance to those instructions, and we expect that they will be followed. Regarding the defendant's family, in no way is the state intending to use its subpoena power in order to exclude Mr. Kohberger's family from the courtroom. The state's not aware of any authority to support this argument that the defendant has a Sixth Amendment right to have his family in the courtroom. He, of course, under the Sixth Amendment, has the right to a public trial, but that's not his choosing of who is in that courtroom. Totally understand it's within your discretion to allow certain immediate family members in the courtroom to support Mr.
The reason you
Kohberger.
can't simply take up whatever family members you may need to testify in your case in chief right at the beginning. Other than, obviously I know you have a narrative on how you want to lay these things out, but what I will tell you is both sides ought to get used to the idea that with a 3-month trial, the trial schedule will not be held hostage to your narrative. In other words, we'll be taking things out of order, stopping witnesses to put another one on to make sure we get them through them and picking them up again. And so is there a reason you couldn't call whatever family members you need right away?
Well, I will say, we have no intention of calling all the family members. We have the intention of calling a few of the family members who serve certain purposes. I can't think of a reason that we couldn't. Obviously, it's not ideal. It's completely out of context. It's out of order.
This is like a gumbo. You are going to put all the pieces that go into the pot. And at the end of the day, the jury's going to decide whether it's a good soup or not from the state's perspective. And so I think we get too obsessively stuck on the idea of exactly the order these things need to come in, right? And so I'm not sure why you couldn't call the family members you need up front, and then we take away this concern. I can certainly understand from the defense perspective the need and desire to have the defendants support family here in the courtroom.
I do too. And I guess my preference would be for that, even though it would be out of context and interfere with the state's preference of how to present its case. And I think I do take issue with the defendant being able to direct how the state presents its case to a jury. However, if our options are the immediate family members staying in the courtroom and hearing all the testimony of other witnesses versus calling them out of order, it would be our preference to call them out of order. Thank you.
Judge, I knew that the state's position was that there's no case law to support our position, which is why I just went through several cases where it is his constitutional right, one, for it to be public, and there are cases, as I referenced.
Constitutional right is not absolute and bends to, for example, rules of evidence and other rules. And I'm not aware of anything that says a court can't use the exclusionary rule where in good faith a person who was otherwise entitled to be there, including family members, have to be excluded for some period of time.
And that is why I specifically talked about the point that it is discretionary for you. And there's also, Judge, a level of humanity that I hope that you take to serious heart for his family, who is absolutely devastated and dealing with things like headlines that they're going to be called to testify against their son with these types of communications that are happening. And so we're asking that you use that discretion and that you find that humanity. Thank you.
Thank you. I'm going to take this matter under advisement. The defense raised some cases. I want to read those, though I don't think they were precedent on this court setting. I have reviewed the U.S. Supreme Court opinions cited, but in terms of other states, I'll look at those. I do think, and I'm asking the state to think about to use counsel's word, the humanity. I think that, I can only imagine the family of Mr. Kohlberger is devastated by these things. That's nothing that they did. And I think their ability to be here to see the trial is important. And to the extent possible, while also preserving the state's right to a fair trial, should be something that we seek to do. And I think calling them out of order is one way. Now, I know that there is, I don't know why the state would want to call them. I haven't, reviewed their interviews. I don't know anything. I do know there's been an issue raised by the defense relative to purchases on a alleged family account that could be an issue. And so I do see some issues where family members may be important. And so I think there may be some need for exclusion, but I think the best way to handle that is to get them on and off as quickly as possible at the beginning to deal with that. I'm reserving ruling on that. I want to look at it, and I will issue a written order on that in due course.